please, with the next slide, I just put some introductory notes on the constitutional fundamentals of the legal aid for children in conflict with law in Albania. We have a good constitutional framework in terms of providing legal aid in Albania in general, and combine this with the legal provisions on the children in general. This could provide a good source for the legal aid in criminal proceedings for children as well. This is to say in short, the children have the rights to special protection from the state, and this is the Article 54 of the Constitution, which is providing this this special protection. On the other hand, by combining this provision with the general right to legal defense, mandatory legal defense in criminal proceedings, we could say that the constitutional framework can provide a good source for legislation in general. Indeed, I will just stop in few figures. The number of children in conflict with law according to statistics has been about 800 in 2015, and in 2017 it's again about 780. This shows that there is a target group subject to legal aid which cannot be neglectable in terms of figures. More than 280 minors were ruled as guilty in 2017. Now, whether we do not have clear statistical data whether these children benefited the legal aid, the mandatory legal aid, or they acquired the legal aid themselves, but it is certain that given that the category of children that is coming from is target of this group basically comes from families with limited incomes, we can assume that the majority of this group actually is in need for legal aid. The mandatory legal defense in criminal proceedings has been part of the Albanian Code of Criminal Procedure since 1995. And this means that in general, we have had quite good experience with the provision of legal aid from a normative point of view. Actually, in practice, this has not produced the quality of legal aid which is expected or which is needed for defending as well as possible the rights of children in conflict with law. And this is for the main reason that the system of legal aid in general is underfinanced from the state. Legal aid is an objective of the cross-sectoral justice reform strategy, actually, which was introduced in 2016. And from 2017, as my colleague from Albania mentioned, we have a new law on the legal aid. Now, the legal aid platform differentiates between two categories. The mandatory legal aid is provided in criminal proceedings, indispensable to all vulnerable groups, including children in conflict with the law. While the law of 2017 has introduced the primary and secondary legal aid in civil, administrative, and criminal proceedings, in those cases in which mandatory legal aid is not applicable. And this can be interpreted as a kind of legal aid which can be given to victims. So in case that children shall be victims of criminal offenses. In having this kind of combination, we are now we now believe that we have a full framework for providing legal aid in to the category of children in conflict with the law. I would like to skip the coming slides because they are speaking about the framework, the normative framework, which is presented actually from my colleague. In short, I can only say, so if you can change the slide, we have various normative sources for providing legal aid, starting from the Constitution, the European Convention of Human Rights, which is not only ratified, but it is part of the Albanian constitutional framework. And according to the Constitution, the European Convention on Human Rights is the minimum standard that has to be that serves as the guarantee for the human rights in general. And here we make use of Article 7, Paragraph 3 of the Convention, which provides for the mandatory legal aid in those cases where people cannot afford one themselves. In those cases, it is the state that is obliged to provide. Again, in addition, the Code of Criminal Procedure provides a good source of the normative framework on the legal aid. Various provisions in that code regulate the legal aid for in criminal proceedings, and particularly make it indispensable for various groups, vulnerable groups, where the children in conflict with law are one of them. This is reinforced from the Code of Criminal Justice for Children, which again provides additional guarantees and combines in a proper manner the pre-legal aid with the psychological aid. As another source, we have also the New York Convention on the Rights of the Child of 1989, which is ratified from Albania in 1991. And we can make use of this in order to interpret from a teleological point of view how the legal aid should be understood in practice in jurisprudence in particular. As a general observation, I could only say that we have a very good legal framework in terms of providing legal aid service in general, and the mandatory legal defense for the children in conflict with law as well. But it is very unfortunate that the system is still unable to deliver the expected qualitative service to this group. Why is this? I would like to mention some of the challenges that we are facing in this direction. The first and foremost challenge is related to the pressure of the time. As you just heard, the law was introduced in 2017, although we had the legal aid in place for many years. But with justice reform going on and the fact that the legal aid is now expanded not only to criminal matters but also to administrative and civil matters, given that the legal aid now is expanded to other groups, vulnerable groups, and is made more concrete, in my opinion, it should be expected that the sources will be limited in order to cover the real need for legal assistance from these groups. And therefore, we expect the system to be underfinanced for the coming years. This will certainly have severe severe social costs, because the group of children in conflict with law might not benefit the legal aid which is needed for defending their rights in a qualitative manner. The second challenge is how to, if we can change the slide, please, is to, can you please change the slide? Oh, thank you. The next challenge is how to deconstruct some paradigms. As I said, as I mentioned, the law is quite good in theory. Prima facie, it is manifesting all the rights that are provided in international instruments. But in practice, there are various problems which are coming from the system point of view or from the infrastructure point of view. And here I'm referring actually to the findings of the report on Albania, where the institutional and infrastructural problems were mentioned as crucial reasons for providing not proper legal aid to children in conflict with law. Providing, given having regard of the findings in the report, one of the challenges is how to prepare, how to make the facilities in such a way that children are interrogated and adjudicated by preserving the privacy of the children. The fact that the element of confidentiality and friendly environments are not duly observed not only endangers the professional legal defense for the child, but compromises also the results of investigation in general. It is indispensable to observe privacy not merely as a human right, but primarily to observe and to defend the future of child from any social prejudices in the future. Secondly, and this is very this is again another infrastructural problem, is that we do not have a unified friendly facilities in all courtrooms across the country. There are some courts which have tried to adapt the environments, but the majority of them do not have these kind of facilities. There is a distance between the child sitting behind the glass or behind the iron, and there is a problem that in many cases the attorneys and psychologists do not have direct contact with the child, which means that these professionals are being hindered from performing their duties in a proper way, and these facilities should be adapted across all courts in the country. It can be said also that the facilities are missing in prosecution offices or police stations, facilities which can be adapted for children. We, based on the findings of the report, it is regrettable to learn that children and their attorneys do not have enough time to talk in private in order to prepare for the hearings and for the interrogation sessions. And this has certainly very severe implications for the result of the proceedings in general. I would now like to turn to the third challenge, which is related with the professional education in general. There is no education system for legal aid professional tailored for children. And now I would like also to give an answer to one of the questions which was raised a little earlier. There is a session in the School of Advocacy adapted for the for children, but unfortunately, this is, in my opinion, not enough. And what is more, this is not covering the way the legal aid is working in practice. Therefore, we are now currently working to prepare education modules, training modules for attorneys, which shall be distributed through the School of Attorneys, where more specific information and strategies shall be taught to the new generation of attorneys regarding the way how the legal aid in general works and how the legal aid for children in conflict with the law works. However, this may not be enough. For legal professionals is needed to have interdisciplinary trainings, which means that elements from the psychology and the development stages of the children should also be introduced. We have certainly missing curricula which are relevant for the education and the training of legal professionals in general, but we need also to have continuous education programs for practitioners. We are also facing a phenomenon in the justice system due to the operation of the justice reform. There are many judges and prosecutors which are leaving their offices in the course of the reassessment proceedings, their professional reassessment proceedings. In this regard, there is a drain of experts in this case because there are many judges and prosecutors who are quite familiar and have experience working with the children's rights, and they might not be in the system anymore. This requires the adoption of programs for educating of judges and prosecutors, but also judicial police officers, as well as administrative personnel of the courts, in order to prepare to increase the experience with the children's rights in general. Now I'd like to turn to the fourth challenge. If you can change the slide, please, thank you. How to integrate the existing capacities which are in the system. Actually, there is a valuable expertise developed from the civil society centers and legal clinics over the years. Many clinics have worked and provided legal assistance to children, certainly on a pro bono basis. They have acquired a vast experience in this regard, but the system of the legal aid has not integrated yet. this kind of expertise on the formal ground. We expect this to be done in the future, but the proceedings apparently seem to take longer. In one of the main problems, again, has been the diversion of the resources of legal aid to other, which could be dedicated for children in conflict with law, to other vulnerable groups. As I mentioned, given that the legal aid scheme is expanding also to other cases other than criminal cases, the budget will not suffice for covering the real needs for the legal aid to the children in conflict with law, and this will be another challenge for the system in the coming years. The fifth challenge, I'd like to go to the next slides, is how to enhance the quality of the legal aid. One of the concerns raised also from the commentaries in this conference has been the fact that the tariffs for the legal aid professionals are poor. Unfortunately, the system continues to provide the same scheme that has been operational in this direction. The new law on the legal aid provides that the mandatory legal aid shall be provided from the institutions that conduct the proceedings, let's say the prosecution system or the court. They have their own, the tariffs that are in place actually have not yet been revised, but there is a huge need to revise the tariffs for the lawyers because they are very low and they are not attractive to professionals, good professionals that have expertise and that can provide added value to the system. What has been observed is also pure institutional cooperation between the Chamber of Advocates, the Albanian Bar Association, and the Ministry of Justice, which is central for organizing the state aid, the legal aid in mandatory proceedings as well. Based on the observations of the report, the selection mechanism for mandatory attorneys at law is not based on merits, and this is another institutional problem which has to be addressed in order to ensure that all the attorneys that are part of the list become involved with legal practice in this case, and that by means of legal practice, they also strengthen their skills and be able to provide more professional expertise in future. Again, here, the continuous litigation programs and specialization strategies which are missing need to be introduced. The last slide is related with actually there is the last challenge, the previous slide actually. If you can make one slide previously, I think. How to change the mindset of professionals working with children in law, in conflict with law. Actually, the current mindset is compromised from certain opportunistic behaviors prevailing in the mandatory legal aid area in general. Attorneys are not doing their best in order to protect the rights of the children. Very, very often they just make their duty formally and treat children as they were adults. This is very regrettable actually, and this mindset should be changed indispensably as soon as possible. We believe that the code of conduct fail to address these professional standards, which should be tailored for services provided to children in conflict with law. Specialization of professionals through intensive participation in proceedings is missing, and there are still present model of treating children as they were ordinary or adult accused persons, which is very, very, very unpleasant to see. Finally, if we can go to the last slide, based on what we have evidence from our experience as well, and from the report, we believe that it is indispensable to anticipate the full implementation of the legislation on legal aid for children in conflict with law. Not only the mandatory system, but also the legal aid provided for the primary and secondary legal aid should also be operational as soon as possible in order to assist not only the children that have problems with the law, but also their parents on how to get oriented with the justice system and how to provide the best defense for their children. From the infrastructural point of view, the new facilities, friendly facilities for proceedings against minors in all countries should be introduced in a unified way. The institutional cooperation should be enhanced, and certainly should be introduced a fair system for appointment of attorneys at law in mandatory legal aid cases. And in the training direction, it is very important to implement interdisciplinary training programs for all professionals involved in the system, including attorneys, psychologists, judicial police officers, prosecutors, judges, and administrative personnel. And finally, it could be suggested to introduce guidelines and upgrade the deontological rules for each category of legal professionals working with children in conflict with law as an indirect way of increasing quality in the legal service. With that, I would like to conclude and certainly be open for any questions that can be